So welcome back, and this is our tutorial for week 5. This is the first half on chapter 23 and a catch up on the previous work on chapter 6. So as usual, we use the Wentworth-Miller method to plan and find the legal issues at the end that we will use for our ILAC, especially for the final exam. Let's start with this Pearson simulation. Now in Toowoomba, in Springfield, I'm going to introduce a different type of simulation from another textbook by Wiley. Okay, it's called Business Law by Nick James. And I want to just compare and contrast the two simulations if you think one is better than the other. Okay, so we'll pick up on that hopefully as well next week. All right.
You are the director of Vision Properties Proprietary Limited, a private company that specialises in sustainable property development and urban renewal projects. You are preparing an application for a zoning variance. When you arrive at the council chambers with your application, you see that the council is exhibiting proposed plans to redevelop the abandoned waterfront district, which consists of derelict warehouses facing the old port. An architect's model shows a modern version of a village built around a central park space, with shops, a school, bus station and a police station. The side nearest the river has medium-density luxury apartments with water views. Accompanying text states that the redevelopment of the area has been authorised, and that the plans are an example of sustainable urban development proposed for the Port Precinct to allow council residents and potential purchasers and developers to envision the site's potential. No prior proposals had been exhibited, and council has not held any preliminary discussions about the possibility of redevelopment. You know that the land where the warehouses are located is inexpensive now, but would dramatically rise in price if the entire precinct was redeveloped as shown in the council's display. You must decide whether to pursue this development opportunity and determine what your options might be if the proposed development does not go forward. You think the council's proposed redevelopment is a potential opportunity to grow your business. Before making any decisions, however, you decide to talk to some of your business associates to help weigh your options. Jumping in too quickly may be risky, but the risk may be worth taking. Ryan, your business advisor, says,
"The longer you wait, the less money you'll make. Act quickly if you want a profit."
Click Next. James, your solicitor, says,
"These plans sound exciting, but have they been fully approved? You must consider the risks you face if you purchase property and then the council abandons the project. If this happens, you could potentially take legal action, but there are a number of elements that must be established to succeed in proving negligence."
Samantha, your friend on the council, says,
"The approval is a significant issue. This is the type of project that normally succeeds in receiving budget appropriations. But the political and economic climates are uncertain, and nothing is written in stone."
Click Next to continue. Now that you have considered the advice you received, what do you decide to do? Select an option from the choices on the right.
All right. So the first one says buy the land. Okay, buy the land that the council plans to develop now before prices rise. So this is the business hat. Or ask for further information from the council before you buy any property. This is pretty much the solicitor. And buy the land, third option, that the council plans to develop now before prices rise, but also ask the council for more information about the plans. Any discussion here? Yes, Luke.
Because I guess you would want to buy the land before the council plans to develop it, but at the same time you want to know all the risks that are associated with it. Like, you don't just want to jump into it
Okay.
without any information about it. You need to know
Yeah.
as much as you can, but at the same time, if it is as good as people are saying, you want to make sure the price is as low as they possibly are.
All right. So you can see that the third option is simply the combination of option 1 and option 2. Anyone disagrees? Anyone has different ideas?
I'd say ask further information from council before you buy the property.
Okay, so Damien says, better to ask, he wants option 2. Just ask for further information. So what about then, why do you think this is the best option? Why not, for example, try to get this rise in prices in profit?
Well, if the council goes back on what they were doing, or what they said they were going to do, if it is only, if it hasn't actually been approved, if it's only just been proposed, there's a lot of difference between one and the other.
Okay. What else can you say in support of this second option? What do we, yes?
Zoning, you can't be sure of what the land is going to be zoned for until you've really checked it all out.
Okay, so you are not sure. What do we call this idea of trying to, get this increase in price, even though it's not really sure? We call it what? Starts with an S. Speculation. We call it speculation, right? Now, think whether your shareholders, if you are, for example, one of the executives, okay, or a CEO, think whether your shareholders would be really happy about you going through speculative plans to make profit for the company. Okay, so which one do you want to go with as a group? So someone says 2. Are we happy with 2 or 3?
I'd say so, because you might be able to get more information by going with option.
So you're happy with 2 as well? Everybody? Let's do 2. Okay, select.
You request more information from council. This takes some time and, in the meantime, as news of the proposal spreads, speculative buying is driving prices up by 15%. When you finally get word back, it is only that the plans are subject to budget approval and appropriation of funds. What will you do? Select an option from the choices on the right.
You could either conduct your own investigations in an attempt to verify the probability that the council will approve the budget, or buy now again, as prices have already increased, and if you keep waiting, the possibility of substantial profit will be reduced. Not as much as you're trying to speculate now, but you're trying to really not pay a lot for this land.
There are 2 options.
Yeah, so the third option is the one at the bottom, hold out and wait. Still, hold and wait until information is made public about the finality of the plans. So at the beginning, we were saying, okay, this is speculation, maybe we should wait. We don't want to go through speculation. What about now? You see that the price is already rising, and you know that these plans are simply subject to budget approval. So are you going to wait for budget approval? By that time, of course, the prices, if they get the approval, or they might not at the end. But the point is that the price is going to be plateauing at a very high level. Or they might collapse completely, and then, of course, you don't need them in the first place.
Would it be an idea to probably go to option 1, because it's taking an excessive amount of time to get information from the councils, and it says conduct your own investigations. Like, of course, that might not be legal, but it might be actually, no, that might not be legal. I was going to say that might be a quicker way to get the information you want.
How would you know? How would you still know that they will approve the budget or not until it's actually approved? You might actually have someone on the inside to tell you which way they're going to go. Huh? What do you think? Which option should we go with? Pick one. Anyone has a strong feeling about one of these options? Anyone? Should I choose for you? I would play it safe. Just hold. Okay.
You receive a message from your friend on the council telling you that the council has abandoned the plans for the redevelopment as budget approval has not been received. The value of the property drops by 20%. As a result of your sharp business skills and due diligence, you have avoided a potential loss that you could have suffered had you invested in the property. Click Next. If you had bought the property, would you now have a negligent misstatement case against the council? Select an option from the choices on the right.
So this is what really we are interested in. Negligent misstatement. Okay? What's the first thing you need to see in order for you to answer this question? Yes? You want to look at the elements of negligent misstatement. It's not nuisance. You are given the premise. This is very easy. They tell you what the premise is. You just need to find the elements. So the elements should be in chapter 6. And they are under page 175. Okay? In fact, the elements are on page 177. Let's look at them together. So that's my point, you know. You don't rush to answer. You need to see the elements first. It's going to be very easy in the exam because they will be given to you or you will have them as part of your package that you will take with you to the exam. Okay, we missed that, so we'll have to go start it from the beginning. That's one of the problems with these multimedia. But let's go to the text and maybe we'll just leave it there. Here we go. In brief. So this is the kind of thing maybe you will photocopy or maybe you'll just have your notes, you know, on this. So I hope that everyone is going to have like a table of contents for your notes, and each one of these headings in your table of contents is going to be a cause of action. One of them, for example, is negligent misstatement. So based on the facts we just saw, is there a duty of care on the council? So it says, regards must be given, this is the existence, to all of the circumstances of the case, and while reasonable foreseeability is important, the relationship between the parties, combined with reasonable reliance by the recipient on the misrepresentation and an assumption of responsibility by the speaker, must be shown. In addition, the court may take into account these other factors. Based on the facts, what did we say you knew about the representation that the council was making? This was not made to you. When you went into the council, you found out about the plans. It's just like, what? An advertisement, right? It's something that they're telling everybody about. Now, in relation to you, do you think that the council owes you a duty of care based on these facts. Okay? So the idea that you realize quickly that this is only tentative in the sense that you will have to wait for final approval. Okay? So then you have to ask yourself whether there's a misrepresentation here or not. Okay? So I'll leave it there. The point is that in order for you to answer a question about negligent misstatement, I don't want you to start your answer by saying, no, there is no negligent misstatement or the council is not liable. You'll get a C for conclusory if you pass. You have to start from the top and go through your analytical structure. Okay? And we will go through some of these questions after the break, so I'll take you through them actually one at a time. All right. Let's continue then with another question. This is from 654, again from chapter 23. It says, Erica paid for goods she bought at the electronic checkout by the exit turnstile of the supermarket. Just after she paid for the goods, Cam, the floor supervisor, okay, just like the casino, right? The floor supervisor took over the exit and mistakenly, this time it's mistakenly, believed that Erica had not paid. Refused to allow her to leave with the groceries unless she paid for them again. I'm sure you've heard something like this from Grand Central in the Chronicle about a woman that had problems with the new layout at Kmart. Was it Kmart? Yeah? Something similar to this. That would be a good question for the exam, right? Erica refused. So he refused to allow her to leave unless she paid for them again. Erica refused. So Cam asked her to accompany him to the to the office, just like in the casino, to discuss the matter further. So when this comes in the exam, for example, I want you to see that analogy between the casino case and this case, right? And you have to cite that as well, if you can. Okay, it's not going to make you fail if you don't, right? But if you are looking for an A on HD, that's what you're doing. When Erica refused, Cam took her by the arm. This time, not put your hand on the shoulder, took her by the arm and started to pull her towards the office. So Erica responded by first telling Cam to stop, and then, when he did not, she hit him in the face with her grocery bag. This is in front of everyone, knocking him unconscious. And all you'll get in the exam is discuss. I'm not going to tell you what the premises are. Okay, let's start our thinking process. You start your thinking process by saying what? Who are the parties? Who are the parties here?
Cam and Erica.
Okay, so you're saying Cam is going to move against Erica, so he's going to take her to court for what? What does he want? What does he want? Punishment. And it's going to be for assault, someone said? Okay.
Actually, we need the battery because I actually need
Okay. So someone says, baby Cam can take Erica to court. Okay, he wants to punish her for battery. You're not sure. Why don't you put them both down? This is your planning with a pencil, maybe, you know. That's it. Those are your parties here. Cam and Erica. Slowly you'll note that what we're talking about is different, a little bit at least, from the answer you have in from the author of this book. So we need to really look at all the possibilities. Someone said Cam against Erica. So it's Cam versus Erica. What you're going to do is going to write something, Cam so when you start your writing, you'd say something like Cam, and then not keep repeating it. You'll give it an abbreviation C. So every time you write it later on, it's going to be only C. Versus Erica. That's it? Thank you. So someone says Erica could take the supermarket. What does she want?
Compensation.
Okay. She wants compensation. So what's the premise that you are going to raise? Which premise are you going to investigate? You don't know. Okay. So anyone can help us? Erica moves against Cam. And of course, Cam, the vicariously liable party for that, the employer, would be the supermarket. Remember vicarious liability? You can get the money from the supermarket. And how are you going to do that? You're going to... Which premise? What did Cam do to Erica?
Well, sort of. He tried to force her to go to some place when she'd actually done nothing wrong. She paid for her.
Forget that for now, whether she paid or not. All that we're looking at is what he did. What did he actually do? What is his positive act? Perfect. Thank you so much. So someone said he basically took her by the arm and started to pull her towards the office. Now, this, before you look at the elements, looks like what? There's physical force here. It could be assault, but so what does she want? Okay, so this is because our criminal code now talks about battery and assault as one cause of action. So it is criminal, but at the same time, when you go to the magistrate court, they will look at the monetary compensation. Okay? So I'm not too worried if you want to go assault or you want to do assault battery. Okay? But this is battery because there was actual use of physical force. Okay? So now you have Cam against Erica. What is that cause of action? Most likely battery because she hit him with the shopping bag. Erica against Cam. And then you would talk about vicarious liability against the supermarket. You go through the elements, and we have looked at, and you have them in your handout, what the battery elements are. So you have to talk about the positive act, and so on. Okay? And then if there is any issue, you think there's tension somewhere, then you explain that in your writing. Okay? So we looked at the legal analysis, at least in a nutshell. This is the most important part of the whole thing given to you. These are the operative facts, or the material facts for our premises. Okay? It's very important that she told him to stop. If you start immediately using physical force, that will reduce your chances of making battery, because we're going to talk about self-defense. Okay? So remember, battery is that there's a positive act. So in the first instance, it's what Cam did, pulling her from her arm. Okay? It is intentional. There's no problem with that here. Bringing about an immediate or direct harmful or offensive contact to the plaintiff, and explain how she felt. And it's contact that's not generally acceptable in the ordinary conduct of life. So you'll have to say a few sentences about each one of these elements. Then remember that what she did, if Cam turns around and says, I'm going to take you to court, okay, because you hit me with the bag, okay, there's a defense, of course, to both, actually. Okay? So the first one is that taking her arm and pulling her towards the office. Now Cam has committed battery on Erica, but also, another premise, Erica's actions in hitting him with her bag and knocking him unconscious would also constitute battery. So the key point here was that we see that you're going for the premise and the second premise. In his defense, Cam, okay, he might rely on something called necessity. He was under the impression that she was stealing, so he was protecting property. But the proviso is that you always have to use reasonable force. In the casino, he simply came and said, come with me. Okay? This guy started pulling her from her arm and so on. Of course, she's refused. So what is he going to be able to do? Maybe there's also the defense of a statutory authority, that I have authority. Okay, so like the legal duty to arrest. Something you could raise, of course, here is whether this Cam made himself known to Erica in terms of his authority. You know, does he have a tag? Is he wearing a uniform? You know, did he introduce himself? You know, I'm the manager, and so on. We believe something. Yeah? To try to convince her before simply trying to pull her and pay for these goods again. Now, she could also raise a counter premise. We call these counter premises. She could raise a counter premise called self-defense. Okay. Again, you have to first take all reasonable steps to avoid using force. And we can see that happening in this scenario because she asked him to stop. Okay? So this is how you always take the facts from the question or from anything and try to superimpose them on the elements. All right. Let's look at another question. Arcus constituted a tennis court in the backyard of his house at Scarborough. On one side of his land was a park, and on the other side was a house belonging to Abbott. After many years of playing tennis, without any complaints from Abbott, Arcus installed lighting to enable him to play tennis at night. The lights were sufficiently powerful to light up not only his tennis court, but also his neighbor's house. As tennis was played until nearly midnight on a regular basis, Abbott suddenly found that he was getting a lot less sleep than he used to get. Now your job is to advise Abbott whether the actions of Arcus amount to good grounds for a cause of action in private nuisance. So it's given to you. You don't have to worry about figuring out what the premise is. That's not going to happen in the exam. You will have to. And the remedy, he should seek giving reasons. So, as we said previously, the starting point is to look at the elements for private nuisance. So, again, you know if Abbott is going to go to court, so it's going to be Abbott against Arcus, he wants what? What is he after? Monetary compensation? Does he want money? Sorry?
Couldn't you just fix the light and resolve the issue like through like an ADR rather than going?
Absolutely. If they try that first, that would be even better. But don't go and talk about that in the exam. We're asking you about private nuisance. You have to advise private nuisance. What does Abbott want? Money? Is he going for compensation or punishment? He's going for what we call an injunction. He wants to stop Arcus from playing at night. So the first starting point for us is, so these are again the relevant, so you'd highlight these, for example, in your exam to make it easier for you to go back to them. Okay? So the lights were sufficiently powerful to light up not only the tennis court, but also Abbott's house, and Abbott started getting less sleep. So you have this in your notes or in this handout I've just given to you, and you have it with you in the exam. So you flip to private nuisance and you'll find that there are two elements. There has been an indirect, substantial, unreasonable interference with the use or enjoyment of the land by the defendant. Who's the defendant?
The tennis court owner.
Arcus, and the plaintiff, Abbott. Now, what is the indirect interference? The lights. What is substantial interference? Not yet, because we have to look also at the damage at the end. Okay, but substantial in what sense?
Almost midnight.
almost to midnight and on a regular basis. Everything is there for you to throw out the elements. Okay? What about unreasonable? What would a reasonable person do? For example, you talk again about midnight. You know, do you have to play all the way until midnight? So even if there are lights and you want to play at night, it doesn't have to be every day at midnight or on a regular basis to midnight. So these are the factors that you need to look at. So this is how you get the A's and the HDs, all right? We're looking for someone picking on this. Duration, so someone pointed that out. Locality, you know, where you are, how close to this neighbor. And the other side, that's just a park. Gravity of the harm, what's the harm here? Loss of sleep, how did that affect Abbott? And the motive, why are you doing that? Is there malice? Are you trying to actually irritate this neighbor or not? And alternatives. Someone talked about the ADRs. You know, what else can you do?
Well, what's his face? Couldn't Abbott get potentially more curtains on his house or something to block out the light potentially?
So it's only the light, or there's also noise. So that's something you can raise. Who's going to pay for the wall? I mean the curtains. Is it going to be Abbott or
Pay for them
himself? But it's not his fault. It's not his fault. He's not the one who's causing the problem. Shouldn't the guy who's causing the problem pay for it?
Potentially, but he said that noise was never an issue for him.
Okay. So what is the issue?
It's just the lights.
So we're not going to go through that here, but there's something called law in economics. Okay. It's a discipline called law in economics, and it analyzes who should pay for what. It's not necessary that it's actually going to be Abbott that's going to be paying, because simply, you know, it was Arcus who caused this problem. If it's actually more efficient for Abbott to install the curtains, you find that the court would tell him actually to do so. But not in this case, of course, because we're talking about nuisance. Here the question is simply whether the court's going to grant an injunction or not. Okay? So Abbott must also establish that he suffered from damages. Damage in the sense of loss of sleep. This is how you go through the question. Okay? You have this, you know that's going to be private nuisance. All you have to do is move the facts so that you cover the elements. So instead of talking abstract, you show us that you're talking about that actual scenario, just like you're doing in your ADRs. So when you talk about any of the ADRs, it's not going to be just talking about a negotiation or mediation in abstract. You always have to talk about what's happening in your scenario. All right. So to wrap up, again, Abbott needs to show that there has been an indirect, substantial, unreasonable interference with the use or enjoyment of his land. Okay? And this seems to be satisfied by the facts that the bright lights, the noise at midnight, a regular basis, and interfering with his sleep. Okay? The usual remedy, as I said, you have to look at the defenses and the remedies. The usual remedy is an injunction to stop the defendant from continuing the nuisance if it can be shown that the nuisance is likely to be a continuing one. And damages, okay, are available only once damage has occurred. What does that mean? Damages are available once damage has occurred. What's the damage here? So the damage in this scenario was what?
Lack of sleep.
Lack of sleep. And the damages is the monetary compensation. Damages are available, money is available only if there is damage has occurred. So this loss of sleep, what did it lead to? Okay?
We probably can't concentrate at work.
At work, your loss of productivity, so on and so forth. How are we going to prove that? All right. So what else do we have for today? That's it. We'll leave it for now. And in Springfield, we're going to work on just stay seated for a moment, please. We're going to work on the beginning of contracts, chapter 7 and 8. I just need 10 minutes of your time, please, to fill out this half or midterm survey so that we can move forward knowing better what you think should be done for the next 5 weeks. I'll be waiting outside. So can I nominate someone to be the sort of umpire here. Can someone just, collect don't put your name on these, please. Just collect them from your fellow students and put them for me in this envelope. And once you're done, just let me come back. So I'll give you 10 minutes until 10:20, please. All right, so who can be my helper here? Okay, Luke. All right, so just put them in this envelope. I'll leave it right here, and I will just wrap this up and go.